Hello everyone, today we are going to check the editorial of the Hindu on July 20th, 2025. So it is about clearing the air on citizenship in Bihar poll roll revision. So now it's a hot topic that in country we are discussing about. So the Election Commission of India, the ECI, has launched a special intensive revision, that is the SIR of Bihar's voters list, the first since 2003. The intent of this is to update records, remove ineligible voters, dead, migrated, duplicate entries, and curb illegal immigrant enrollments. The revision targets nearly 80 million voters, many of whom must now submit multiple documents, including birth and citizenship proofs, to validate their eligibility. So now we are going through the editorial that's discussing about the SIR in Bihar, that the election will be in future in the Bihar state legislature. So we are going to discuss about this particular editorial. So it was written by G. Rajagopalan. It's a senior advocate and formerly additional solicitor general. So today we are going through this editorial in a way that how much this will help in the UPSC mains preparation as well as for the prelims as well. So let us go through, let us read all this which is there in the article, and to highlight properly which all are the things needed for the exams and how to make a point-to-point notes which will be helpful for the UPSC aspirants. So let's start. So let me start. So clearing the air on citizenship in Bihar poll roll revision. So it is about the poll roll that's related to election and the citizenship and things. So let's start. It is fundamental that unless a person is a citizen of India, he cannot be an elector. Consequently, he cannot become a legislator also. So in the starting, it was saying that unless a person is a citizen of India, he cannot be an elector, and at the same time he can't be a legislator also. That means if a person is not a citizen of this country, he can't participate in the election, as well as at the same time he can't be a candidate or a member of the legislature, which is the parliament as well as the state legislatures and other bodies. Therefore, it is very surprising that some seasoned politicians have raised objections to the Election Commission of India, that is the ECI's special intensive revision, that is the SIR of electoral rolls in Bihar, where assembly elections are expected shortly, that citizenship should not be verified. So it is about the citizenship should not be verified. It only demonstrates that they have absolutely no knowledge of the constitution and working of the system. Article 324. Now it's mentioning the Article 324 of the Indian Constitution, which is the part 15 of the Indian Constitution. In that, the heading elections, this Article 324 of the Constitution provides that superintends direction and control of the preparation of electoral roll and the conduct of all elections. So Article 324 is mentioning here that it is a superintendent's direction and control of the preparation of electoral roll. So under Article 324, it was saying that the preparation of electoral rolls and conduct of all elections shall vest. So shall vest means it is mandatorily saying that in the election commission. So that is the sole, that is the duty of the election commission, that shall vest in the election commission. So superintendent's direction as well as control of the preparation of electoral roll and conduct of elections are vested in the election commission under Article 324 of the Indian Constitution. Then the preparation of electoral rolls is a continuous process and is revised from time to time irrespective of there being elections or no elections. If there is an election or if there is no election, then also the electoral rolls is a continuous process. The preparation of electoral roll is a continuous process and is revised from time to time. So it was said by the Supreme Court in the case of Lakshmi Charan Sen and others versus AKM Hassan Uzzaman and others, etc. Yeah, 1985 SC. This is not that important to read, but this particular case law is important regarding this, that whether the election is there or not, the continuous process need to be there. That is under this particular case law which was mentioned here, which was said by the Supreme Court. So we are going through the Article 324 about the election commission's superintendent's direction and control of the preparation of the electoral roll and conduct of the elections shall vest in the election commission. So shall is kind of, it is mandatorily. So next, so it is on clarity on being a citizen. So Article 326, before it was Article 324, now it's about 326. So that we can write here Article 324, then now it's Article 326. So this Article 326 of the Constitution of India provides that the election to the House of People, that is the Parliament, and the legislature of every state, that is the state legislature, shall be on the basis of adult suffrage. That means, that is to say, every person who is a citizen of India and who is not less than 18 years of age in such date as may be fixed in that behalf by or under any law made by the appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on certain grounds. So that grounds were defined in Article 326. That's the non-residence, unsoundness of mind, those are the grounds. So that is said in the Article 326. Therefore, it is clear that unless a person is a citizen, he is not entitled to be registered as a voter in any election. So if he is not registered as a citizen of the country, that's India, he is not entitled to be registered as a voter in any election. So pursuant to the enabling provisions, the Parliament enacted the Representation of the People's Act 1950. That is the RPA 1950. We have written what are the main points. That is Article 324, then Article 326, then RPA 1950. That is a Representation of People's Act. So the Representation of People's Act 1950, which deals with the preparation of electoral rolls and delimitation. Under the Representation of the People's Act, the preparation of the electoral rolls and delimitation. Then the preamble of the 1950 Representation of People's Act read as follows: an act to provide the allocation of seats in and delimitation of constituencies for the purpose of elections to the House of the People, that is the Parliament, and the legislatures of the state, that is the State Assembly. The qualification of voters at such elections, the preparation of electoral rolls, the manner of filling seats in the Council of States to be filed by the representatives of the Union territories and matters connected therewith. So it was saying about the purpose of it is about, first of all, it said that the preparation of electoral rolls and delimitation. So this act is particularly under 1950 Act of the Representation of Peoples Act 1950. It is about the purpose of election, the constituencies, delimitation of the constituencies for the purpose of elections to the House of People and the legislatures, to the Parliament as well as the state legislatures. The qualification of voters at such election were discussed, were said in the particular act. The preparation of electoral rolls, which was there in the act. Then the manner of filling seats in the Council of States, that in Council of State it is the state assembly is there, so the people will vote and the state assembly, the MLAs will be elected, so to be filled by representatives of the union, that will be done by the Parliament because of the union territory, so the matter connected therewith. Then under Representation of Peoples Act 1950, the Part 2A of 1950 Act deals with the officers of the commission. The officers of the commission, which includes electoral registration officers, and assistant electoral registration officers. So the act deals with the officers of the commission, which includes electoral registration officers and assistant electoral registration officers. It was mentioned in Part 2A of the 1950 Representation of Peoples Act. Then the Part B deals with the electoral rolls of parliamentary constituencies, that is the MPs. So Part 2, it is 2. Then Part 3 deals with the electoral rolls for assembly constituency. So this is about the state assemblies. So first of all, it is about the officers of the commission, election commission, which includes electoral register office and assistant electoral register officers. Then Part 2B deals with the electoral rolls for parliamentary constituencies, that is for the MPs. Then Part 3 deals with the electoral rolls for the assembly constituencies, that is the state assembly. So this is we have discussed. So then it is the section 15. Section 15. You can make notes by making bullet points, like you can make notes. At the last of the video, I will show you how to make that. That's how I made that notes, by taking or written all these bullet points from this particular article. So let's continue. Section 15 of the 1950 Act deals with preparation of electoral rolls for every constituency under the superintendents. Then the direction and control of the election commission. So section 15. So it is now about section, right here, section 15 of the RPA, Representation of People Act. Now it is discussed about the roles for every constituency under the superintendent, direction and control of the election commission. That was said in section 15. Okay, now it is section 16 of the 1950 Act deals with disqualification. Before it was about the direction and control of the election commission, now it is about the disqualification for registration in an electoral roll, which was in the section 16 of the 1950 Act, and specifically section 16 clause 1 clause A, which provides that if a person is not a citizen of India, he shall be disqualified for being registered as a voter. So under section 16 clause 1 clause A, we have already discussed this section 16, that is about the disqualification for registration in the electoral rolls. Then next it is about the section 16 clause 1 clause A of the Representation of the People Act. It provides that if a person is not a citizen of India, he shall be disqualified for being registered as a voter. So he will be disqualified if he is not a citizen of India, if a person. And further, it is section 16 clause 2 provides the name of the person who is so disqualified, even if registered, shall be struck off from the electoral roll. After disqualified, even if it is registered, shall be struck off. Even after he is disqualified, then he is registered, that will also be struck down under section 16 clause 2. Next, besides this, section 20 of the Act also provides who is ordinarily resident in a constituency. So section 20 of the RPA Act, it's of the 1950, the Representation of People Act, is about provides who is ordinarily resident, which is described in section 20. Then in section 21 deals with the preparation and revision of electoral rolls. It is about the preparation and the revision of electoral rolls, that is section 21. Then we're going through this section 22 deals with the correction of entries, in the electoral roll. The correction of entries in the electoral rolls deals with section 22. Then now it's section 23. So it is now section 23 deals with the inclusion of names in the electoral roll. It is about the section 23 is about the inclusion of the names in the electoral roll. Then it is section 24. Section 24 provides that if anybody is aggrieved by an order of inclusion or exclusion, they can prefer an appeal to the authority referred to in this section. So if it is if any aggrieved person is there, that by an order of inclusion or exclusion or something happened, you can go for an appeal. So that is said in section 24 of the RPA Act. So move on. The only period during which no amendment, transposition means that from one booth to another, we're changing. So that is a transposition. So amendment, transposition or deletion is permitted is referred under section 23 clause 3 of the 1950 Act, which provides section 23 clause 3, that is about which that no amendment, transposition or deletion is permitted. These things are not permitted under section 23 clause 3, which provides that no amendment, transposition, deletion or inclusion shall be made after the last date for making the nomination. After the last date of making the nomination, you can't amend or transposition or deletion or inclusion, nothing can be changed. Therefore, it is fundamental that unless a person is a citizen of India, their name cannot be included in the electoral roll, and if it is erroneously included, it can be deleted under the provisions as stated above. Under the duties of the Election Commission. So in fact, the duty of the election commission to verify whether the name of any non-citizen has been included in an electoral roll if a complaint or doubt in this regard has been raised. So it is a duty of the election commission, that is ECI, to verify whether the name of any non-citizen has been included in an electoral roll if any complaint or doubt in this regard has been raised. If any doubt in this regard is raised, it is a duty of the election commission to check whether the inclusion of any of the name of the non-citizen is there. In fact, to put it otherwise, the election commission or its officers have no jurisdiction to include a non-citizen's name in the electoral roll. If it is so, it is null and void. So if the Election Commission of India or its officers have no jurisdiction to include a non-citizen's name, if they don't have any authority to include a non-citizen's name in the electoral roll, then if it is so, if they try to do it, is null and void. It is null and void to include a non-citizen's name in the electoral roll. Therefore, if an application is made for inclusion or a complaint is received that a non-citizen's name is included in the electoral roll, it is a duty of the election commission to conduct an inquiry as necessary to ensure that non-citizens' name are rejected and deleted. So if it is included, it is a duty of the election commission to conduct an inquiry as necessary to ensure that non-citizens' name are rejected and deleted from the list. So it is also the duty of the election commission. If the election commission fails to do so, to check whether the non-citizen's name is included, it would be failing in its constitutional duty and the purpose for which the power has been granted under Article 324 and 326 would be defeated. So 324 we have discussed, it is a superintendent's direction and control of the preparation of the electoral roll, that is 324. Then Article 326, it is about the election in the House of the People as well as the legislature, the adult suffrage, and also the age of 18 and also be a citizen of India. That was discussed in 326. In the same line, if you proffer to be member of legislature assembly or a member of parliament, that is MP, one has to be a voter in a constituency. They need to be a voter in the constituency. If he is not a citizen, of India, he cannot be a member of the parliament. That means the member of the parliament should be a citizen of this country, or the state legislature. The MPs and MLAs need to be a citizen of this country. So it is described in Article 102, that we can write Article 102 of the Constitution provides for disqualification of membership of either house of the parliament. That means the Lok Sabha as well as the Rajya Sabha, either house of the parliament, both the houses. So 102 is about of the Constitution is provide for disqualification of membership of either house of the parliament, because if it is a non-citizen, then it's a disqualification for them. And Article 191, Article 191 provides the same for state legislatures. So Article 102 is about the disqualification of either house of the parliament if he is not a citizen of this country. Article 191 is about the state legislature's disqualification, that is the MLA's disqualification. It is very clear under Article 102 clause 1D, that is Article 102 clause 1 clause D, that a person shall be disqualified for being chosen as and for being a member of either house of parliament if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state, or if he is under acknowledgement of allegiance or adherence to a foreign state. So under Article 102, that a person shall be disqualified for being chosen if he is chosen as being a member of either house, that is MP, MLAs, that is the parliament as well as the Rajya Sabha, Lok Sabha as well as the Rajya Sabha. If he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state, or if he is under acknowledgement of allegiance of adherence to the foreign state, that is also shall be a disqualification. That will be a disqualification, that if we choose any other country over India or allegiance or adherence to a foreign state under Article 302 clause 1 clause D, 302 clause 1 clause D of the Indian Constitution, it will be a disqualification. Then it is Article 191. It is Article 191. We will write here 1 of the Indian Constitution. So Article 191 in Constitution, which applies to the state legislature. Before it was for the both the Lok Sabha as well as the Rajya Sabha. 191 is about the state legislatures. Also provide the same. That is also for the state legislature. Those disqualifications, the things which is also applicable in the under 191 for the state legislature. If someone contends that a non-citizen would be a voter, they are also contending that a non-citizen can be a member of legislature, which is nothing but absurd. So therefore, if questioned, one has to prove the satisfaction of the authority that is a citizen of India and that he satisfies the provisions of the Citizenship Act of the 1955. So new one is about the Citizenship Act. Citizenship Act 1955. The RPI of the 1950, that the Representation of People Act, the Citizenship Act of the 1955. So the question is whether to satisfy the authority that he is a citizen of India and is satisfy the provision, whether a citizen need to be satisfy the provisions under Article under the Citizenship Act of 1955. So it was saying that the Section 7A of the Citizenship Act 1955 provides for the registration of overseas citizen in India. So it is about the registration of the overseas citizens in India. That is the Section 7A. Section 7A of the 1955. It is about the registration of overseas citizen in India. And it is Section 7B clause 2 of the said Act clearly provides that an overseas citizen of India cardholder shall not be entitled to the rights conferred on the citizens of India with regard to the registration of a voter. So Section 7B clause 2 says that clearly provides that an overseas citizen of India cardholder shall not be, that the overseas citizen of India cardholder shall not be entitled to the rights. He is not entitled to the rights conferred on the citizens of India with regard to the registration of voter. He can't be considered as a voter. Therefore, the constitutional and statutory scheme, that is a constitution, means under the Constitution of India, the statutory schemes like the Representation of People's Act as well as the Citizenship Act of the 1955 clearly provides that unless a person is a citizen of India, so every statutory is like, statutes like the Representation of People's Act as well as the Citizenship Act 1955, all these things, all these statutes are saying that unless a person is a citizen of India, his name cannot be included in the electoral roll. So if he is not a citizen, his name can't be included. And even if he is included, otherwise if it is included, the authority of the Election Commission can order deletion of the name under section 16 clause 2 of the 1950. 16 clause 2 of the Representation of People's Act, it will be deleted. The Election Commission can order to delete. So it will be section, I will write here, the section 16 clause 2 of the RPA Act of the 1950. It was mentioned 1950. Then it is relevant to note that the decision of the Supreme Court, so the Supreme Court decision can be taken out down, the Dr. Yogesh Bharadwaj versus State of UP and other, was 1993 C 355. That is not important, but this particular case name, Dr. Yogesh Bharadwaj versus State of UP and others. So that case is about which deals with admission in a medical college. Admission in a medical college said that in the said judgment, it has been observed in para 20 that it is only lawful resident. It was saying that only lawful residents that can be taken into account, and if a man stays in a country in breach of immigration laws is present, that does not constitute ordinary residence. So he can't be considered as an ordinary resident, which was said in the paragraph 20 of the Dr. Yogesh Bharadwaj versus State of UP judgment. So it was mentioned. So there also it is kind of saying that he need to be a citizen of this country. So the next is about the Aadhaar and citizenship. It is about the Aadhaar and citizenship now. So one more issue which has to be deal with is whether any person, so this is a question, that whether any person who has a Aadhaar card can be a citizen of India. So that is a question, that whether any person who has an Aadhaar card can be a citizen of India. A reading of the provisions of the Aadhaar Target Delivery of Financial and Other Subsidies, Benefits and Services Act 2016, in particular, that is a section 9 of that particular act, that is the Aadhaar Target Delivery of Financial and Other Subsidiary Beneficial and Services Act of 2016. This section 9 clearly provides that the Aadhaar number or the authentication thereof shall not is important, by itself confer any right of or be proof of citizenship or domicile in respect of the Aadhaar number holder. So this particular section clearly provides that the Aadhaar number or authentication thereof shall not, whether anyone having an Aadhaar number or an authentication shall not by itself confer any right. It won't give any right or be proof of citizenship. It can't be taken as a proof of citizenship or domicile in respect of the Aadhaar number holder. And in that same section 3 of the Act, which deals with enrollment, it's about the enrollment, only provides that the enrollment of the Aadhaar is only provides that every resident shall be entitled to obtain an Aadhaar number by submitting his demographic and biometric information by undergoing the process of enrollment. So it was said that every resident shall be entitled to obtain an Aadhaar number by submitting his demographic and biometric. Anyone can get the Aadhaar number by submitting the demographic and biometric information by undergoing the process of enrollment under Section 3 of the Particulars Act above. So therefore, mere possession of an Aadhaar card is not proof of citizenship. So whether any person having an Aadhaar card, it is not sufficient to say that he is a citizen of this country. And despite the constitutional requirements, if the names of the foreigners are retained in the electoral roll, the rolls to that extent would be void ab initio. It is void at the beginning itself if any of the foreigner's name is included in the electoral roll. So this is how we make a note of this particular editorial in the Hindu on 28th July.